Tonight, trial of Dr. Cassiel Ato Forson for causing financial loss to the state takes dramatic twist as the minority leader petitions Chief Justice to allow a live media broadcast of his trial. We have details from his raging scandal where a private legal practitioner says the Attorney General can be cited for causing financial loss to the state by rejecting the plea bargain request.
For the Attorney General not to have accepted it also raises a question as to the motive for why he wants to prosecute the case. And in some cases, we can even say that the Attorney General could be tried for causing financial loss to the state.
Stay with me for all the emerging details on this developing story. Tonight, Minority Leader Dr. Cassiel Ato Forson is impressing on Chief Justice Gertrude Torkornoo to allow a live broadcast of his ongoing trial because of the public interest the case has generated. There has been heightened public interest in the case after the other accused person, businessman Richard Jakpa, alleged in open court the Attorney General has been impressing on him to incriminate the minority leader. The NDC has since published a call recording allegedly proving this claim made in court. The governing NPP and the Attorney General's department have categorically denied that the AG has done anything wrong. In the last few hours, lawyer for the minority leader says because of all of this, the trial must be broadcast live. Kweku Asante of our legal affairs desk joins me in studio with a copy of this letter from the lawyers of the minority. Kweku, what is the reasoning provided in this request to back the request for a live telecast?
So this letter from Aziz Bamba, an associate, that is Dr. Basit Bamba, a lecturer at the University of Ghana Law School and lead counsel for Dr. Cassiel Ato Forson, was received at the Chief Justice Office on the 30th of May today. And it is titled Republic vs. Cassiel Ato Forson and two others with the case number cited. Dear Honorable Chief Justice, request for full media access, including live broadcast of subsequent court proceedings. It says, we represent and hold the instructions of Honorable Dr. Cassiel Ato Forson, our client, in respect of the above reference case, which is pending before the High Court. We write to formally request the live broadcast of all subsequent court proceedings in the case of Republic vs. Cassiel Ato Forson and two others. This request is made on behalf of our client in light of the recent developments that have significantly impacted public perception of the case and the administration of justice. Our client, Honorable Dr. Cassiel Ato Forson, is the minority leader in Parliament and the MP for Adwumako Enyan Esiam constituency in the central region of Ghana. He was arraigned before the High Court, Accra Financial and Economic Division, on 17th of January 2022 and charged with willfully causing financial loss to the Republic and intentionally misapplying public property. He has pleaded not guilty to the charges. The prosecution closed the case on 14 February 2023, and on submission of no case, the court ruled that accused persons, including our client, had a case in the following on the submission to answer. The trial court held entirely as follows. The court the ruling of Justice Ifya Sewa Sariboche in aligning this. But the letter subsequently makes the point that given all that have transpired around this case, they do believe that granting a public hearing in respect of this is quite important for transparency.
Interesting. Quite some interesting days ahead of us. But the minority leader himself has a statement on this. What does it say?
Yes, the minority leader has put out a statement on social media. It says, in the wake of the recent expose concerning the alleged misconduct of the Attorney General Godfrey Adame, I have instructed my lawyers to petition the Chief Justice for the live broadcast of all subsequent proceedings in the ambulance trial. This request is motivated by a deep commitment to transparency and open justice principles and are fundamental to a fair and impartial legal system. The allegations against the Attorney General are deeply concerning. If true, they represent a serious breach of public trust and a threat to the integrity of our judicial system. It is imperative that these allegations be thoroughly investigated and that the public be given opportunity to witness proceedings firsthand. Live broadcasting the trial would serve several important purposes. First, It would ensure that the public has full access to the evidence and the arguments presented in court. This would allow citizens to form their own informed opinions about the case and hold the participants accountable for their actions. Second, live broadcasting will promote transparency and accountability by making the proceedings accessible to all. Third, live broadcasting will serve a powerful deterrent against future misconduct, knowing that their actions will be subject to public scrutiny. Those involved in the legal system are more likely to uphold the highest ethical standards. I believe that a live broadcasting of this ambulance trial is essential to ensuring a fair and just outcome. It is in the best interest of both the public and the legal system that these proceedings be conducted with the utmost transparency. I urge the Chief Justice to grant my request and allow the public to witness this important trial firsthand.
Well, I mean, some weeks ago, the CJ accepted a request from the Attorney General himself to broadcast the anti-gay cases. What reasons were offered and how do they relate with the reasons in the minority leader's request? Kweku.
So that letter was dated from the Attorney General's chamber to the Judicial Secretary, to the leadership, the Chief Justice. And it says, respectfully, in view of the public interest in the cases concerning the human sexual rights and family values bill, I would like to recommend that the media, including radio and television, be given full access to the relevant courts to undertake a coverage of all proceedings in those cases concerning the bill. The cases under reference are as follows. 1, Dr. Amanda Odwe versus Speaker of Parliament and another. Richard Delaskai versus the Parliament of Ghana and another. That's 2. And then in the High Court, there's Mr. Paul Boamasefa, the Speaker of Parliament, and another. And 2, Dr. Prince Obrikran versus the Attorney General. It is my respectful view that the transparency to be engendered by a coverage of the proceedings will be in the best interest of the administration of justice. That was signed by Godfrey Debordami to the Chief Justice.
Okay.
And it cited the huge public interest in those cases. We know that since then, the Chief Justice had granted this request. And in fact, when Dr. Amanda Odwe and Richard Delaskai cases were all heard in the Supreme Court, both radio and TV were allowed a live telecast. And in fact, on Monday, another case concerning the anti-LGBTQ bill, that is Mr. Paul Boamasefa, the Speaker of Parliament, will be heard at the High Court.
Okay.
And the Judicial Secretary, the Judicial Service have since communicated to Media House that they are allowed to telecast those proceedings in the High Court live. And so the minority leader is relying on this precedent to call for something similar.
And it's, I mean, you see some similar lines there, transparency. So allow it, let the public see this. Now, Kweku, stay with me because but there are more on this Damigate matter. Now, private legal practitioner Samson Ladi-Ayenini is questioning the reasons given by the Attorney General in refusing to accept a plea bargain request in the ongoing trial of the minority leader. Lawyers for the third accused person, Richard Jakpa, wrote to the Attorney General conveying a proposal from Big C Trading LLC to pay €2 million out of the 2.37 million euros the state claims to have lost in the ambulance transaction. We'll hear from Samson Ladi-Ayenini shortly. First, though, Kweku, you're still with me here, and I'm sure you have more on this particular development. Kweku, what were the terms of this proposal from Big C through the lawyers of Jakpa?
So the initial terms was that the Big C company, which is not involved in this case, was going to pay €2 million to the state. And this were the plan. They said they were going to pay €500,000 on the execution of the arrangement. So once the AG agreed to this plea bargain, they're going to pay €500,000. And then within 6 months of execution of this agreement, they would then pay the 1.5 million outstanding. They also demanded that government releases the 30 ambulances in its custody. We know that 30 of these ambulances released through Big C are currently not in operation and are in the custody of government.
So that was part of the request.
That was part of the request. And then they wanted government to discontinue the case eventually. The Attorney General rejected this plea deal because he said the Big C company, LLC, based in Dubai, which is making this request, is not currently a party to the case. So that was the first correspondence between Jakpa's lawyers, which were conveying this proposal from Big C to the AG. Then lawyers for Richard Jakpa again then rise to the AG, saying that the AG says he's not unable to accept the deal because Big C is not a party to the case. Then the lawyers for Richard Jakpa say, okay, if that is the case, then they adopt the proposal of Big C as though it is their own. And because they are a party to the suit, they are the ones now making that proposal to the Attorney General with a little bit of a revise of those proposals.
Okay.
And we know that the Attorney General again rejected that arrangement. We understand within that period, the Attorney General's office sought to know from the minority leader, who is the first accused, whether or not he was in support of this plea bargain. The minority leader at the time said he was not opposed because that is Big C saying they were going to pay the money. If they say they are going to pay the money and the AG is acceptable, the minority leader is not opposed to that. But the AG wanted the minority leader not just to not oppose it, he wanted him to be part of it. But the minority leadership at the time, the minority leader himself, Dr. Cassiel Ato Forson, we understand, said accepting that will mean accepting that you are guilty. And because of that, he was not going to accept that. The AG again rejected that plea bargain agreement. Then there was a third one. The terms now a little bit restructured because Big C through Japa was going to pay 1 million Ghana cedis on 1 million euros on execution of the contract and then pay the rest of that 1 million within 6 months of execution. Again, there was another letter from the AG that said the terms were not acceptable and rejected this deal.
Well, Samson Ladiayanini, who is also host of Newsfile on Joy News, says the AG needs to offer some cogent reasons why he refused the plea bargain request.
We are chasing the money. If one person involved in a matter which we are chasing 2.4, almost 2.4 million euros, and one person out of the 3 accused or 2 accused at a point makes a plea offer of 2 million euros, and we are told that was even enhanced later on, what will be the basis to reject that plea offer? I think the Attorney General owes us an explanation to that issue, because it's the money that you and I are interested in. Yes, a criminal prosecution may lead to jail terms if it is successful and bring deterrence, but there is good reason we have the plea process.
Now, Associate Professor of Law at the University of Ghana, Kojo Appiagyei-Atua, says rejecting the plea bargain request raises issues as to the real motive of the AG in prosecuting this case. He also says the AG may have rather caused financial loss to the state if Ghana does not end up recovering this amount.
The amount that was put on the table was huge. About 90% of the cost that the state has incurred as a result of this ambulance saga. For the Attorney General not to have accepted it also raises a question as to the motive for why he wants to prosecute the case. And in some cases, we can even say that the Attorney General could be tried for the case of causing financial loss to the state, because that is why we have the plea bargaining thing in place, that you're able to recover some money for the state. And if that is on the table and the Attorney General refuses it, for whatever reason, if this is an opportunity for him to make the plea bargaining process work, and he decides to ignore it or overlook it, the question is, what is his motive? And if we should lose this amount of money, then he has caused financial loss to the state. So long as it is proven that indeed there is a blue seal or whatever, that the name of the company said we want to pay this money, then and he refuses, then the question is, why did he introduce a plea bargaining thing at all?
You heard the Kojo Appiagyei-Atua, he's Associate Professor of Law at the University of Ghana, but the national organizer of the governing MPP, Henry Nanabuachi, himself a lawyer, says the AG was right to have rejected the request, insisting the claims the AG may be causing financial loss to the state is an attempt to pollute the minds of people.
Attorney General wrote to Ato Forson, and Ato Forson said that he has no objection to the plea bargain. Then Attorney General wanted to seek clarification and asked whether you are by way associating yourself to this request by way of plea bargain. Ato Forson said no, because you know why? Smartly, he thinks that when he accepts it, it is an admission of guilt. It's an admission of wrongdoing. So I think the good professor should probably get the documents and read, because if he carries this same submission elsewhere, he will be polluting the minds of people.
Harry Nanabuachi is the national organizer of the MPP. And Top Story is always brought to you by Telecel. Let's get onto the phone lines now and do more on this particular developing story. Alfred Tuah-Yeboah is Deputy Attorney General, and he joins us via the phone now. I'm grateful to you for joining. The minority leader is requesting for a live telecast of proceedings. You've done it before. The Chief Justice accepted it. Do you go with the request by the minority leader?
Good evening, my brother. We have no objection to that request, but of course, subject to the discretion of the Chief Justice, because we believe in transparency, we believe in accountability, and we abhor misreporting. And so, if the Chief Justice, in her wisdom, decides that this matter should be live, we have no objection to say. In fact, the AG at different fora had indicated that when it comes to public interest matters, or matters where the public has that kind of interest, it will be the interest of justice that such proceedings are broadcast live on tele and on radio. So we have no objection to it. But as I said, the CJ has the final say. Not only the broadcast, we're also looking at a situation where we can even have day-to-day hearing so that we can get to the end of this matter as soon as possible. So the broadcast, if possible, may have to go with day-to-day hearing so that we can get to the end of this particular matter.
Is that a request you also put before the CJ?
We've not put that request, but because of this interview, I'm just also indicating to you, we will not even be opposed to a request.
Yes, and I'm just asking whether it's a request you would also think about putting before the CJ.
We may, but I'm not going to say that we have taken that decision. I'm just telling you that we will not be opposed to such a request, and we will maybe consider it.
Well, don't you think this is probably a strategy by the team, the minority leaders team, to probably, try to get this issue a bit more complicated? Is that? Don't you think that is what it is?
My brother, we are unfazed by this request.
Okay.
If the minority leader wants this matter to be being live on TV and radio, we are prepared for such a request. But if the CJ in her wisdom grants it, we are prepared to go with it.
Okay. Now, let me just give me a bit of education here. If you look at Article 296, exercise of discretionary power, it says, where in this Constitution or in any other law discretionary power is vested in any person or authority, A, that discretionary power should be deemed to imply a duty to be fair and candid. B, the exercise of the discretionary power shall not be arbitrary, capricious, or biased, either by resentment, prejudice, or personal dislike, and shall be in accordance with the due process of the law. Now, looking at this, was your department fair and candid in rejecting a plea that was paying almost 90% of a debt for which you were prosecuting some people?
Hello,
Mr. Tuebwa.
I didn't get the last part of the question.
So I'm asking that if you look at the law, was your department candid and fair in refusing a plea request that said, I am willing to pay almost 90% of the debt for which you are prosecuting people?
We were fair and candid. The discretion vested in the Attorney General to either reject or accept such an offer was properly exercised. And for that matter, we have no reservations or problems with regard to the decision taken by the Attorney General in rejecting the offer.
I mean, how candid were you then? Because after all, what's the objective of prosecuting the people? It's not to recover the loss that you say they caused the state. So if the company says, I'm ready to offer you over 2 million euros, why not take it?
My brother, when it comes to prosecution, it is the Attorney General's responsibility to mount criminal prosecution. And it is not true that when you are prosecuting a matter, the sole purpose is to recover. It can be to recover or to prosecute and get punishment, or both. And so in his wisdom and based on the offer made, the Attorney General decided that this offer ought to be rejected, and same was rejected.
Hold for me. Let me bring in Sami Jemfi, who is the National Communications Officer of the NDC and a lawyer himself. Sami, grateful for joining here. Now, if you first of all, let's start from the live telecasting. What the AG says they are not opposed to this.
Well, whatever the AG thinks about that is, for me, of no moment to the request that has been made by lawyers for the first accused, Honorable Ato Forson. The Chief Justice is vested with a discretionary power in this matter to decide whether or not she will direct for the proceedings in this matter to be televised, based on very recent precedents that the Chief Justice herself has set, and the rationale for saying, i.e., that matters of public interest need be broadcast live, either on radio or television, so that the public who are interested in the matter can follow and understand, the proceedings. It is our humble expectation that the Chief Justice will apply the same rationale, the same precedent to this request. So we look forward to what the direction of the Chief Justice will be on this matter. Whatever my brother Chia and his friends at the AG's department say about this, for me, is totally irrelevant. They have proven to be very dishonest. My brother issued a press release for and on behalf of the Attorney General on the 23rd of May, 2024 on this matter. At paragraph 2, they categorically denied that the Attorney General has not met any of the accused persons or even contacted them nor sought their cooperation. But today we have compelling, incontrovertible evidence that shows that not only has the Attorney General met the third accused person, he's had several telephone conversations with him. One evidence of one that we've already put out that they have not been able to rebut. And yet, he is not on Joy News issuing an apology for that falsehood he published in that press release. He's here trying to carry favor with the people of this country. It's very sad that the AG's department that is supposed to be the voice for the voiceless and fighters for justice will sing this low. On the issue of financial laws that you asked me, my brother, it is very, very simple. You saw him circumlocating the issue. These same people in the Appiagyei-Atua matter, after they prosecuted and secured the conviction of Appiagyei-Atua for stealing and money laundering of an amount, to the tune of 90 million cedis, were amenable to recover the money. And so they gave Appiagyei-Atua a plea bargain and asked him to pay the money. He paid about 35 million cedis out of that, if I'm not mistaken. And even with the 55 million left, the court gave him a grace period. Now, these same people in this ambulance case, they have a proposal for a plea bargain from the company that was a beneficiary of the contract, under dispute. And the company says, look, if you say our ambulances are defective, no problem. We are willing to fix it. We have actually shipped to you all the medical accessories. They have refused to clear the medical accessories since they arrived at the Tema port in October 2016. It's been close to 8 years. The accessories are there, rotten, so that they can make a case of willfully causing financial loss to the state against Ato Forson and Mr. Jakpa. The company says, no problem. If you will not allow us to clear the medical supplies, to address your concern about loss, no problem. Ship our ambulances to us. Let us give you your 2 million euros, which you claim to have lost. That one, too, the AG says, we don't want the money. Master, they should just tell you that these guys have set out to witch hunt, to victimize,
but Sammy, like he explained
the honorable Ato Forson, our minority leader over this.
Sammy, like he explained there, I mean, plea bargaining is discretionary. The AG is not enjoined by any law to say accepted as soon as it is made. So are we then right to hold him accountable that he decided that he won't accept the plea bargain at that point in time?
Were you not the one who was referencing Article 296 not too long ago?
Where
you indicated that per Article 296, discretionary power ought to be exercised fairly, candidly, and not whimsically or arbitrarily. So if in the case of Appiagyei-Atua, which involved an allegation of stealing of 90 million cedis, an allegation that, according to the court, was proven and established, for which reason Ato was convicted. And yet, in such a damning case, they were willing to settle through plea bargain. Now, can they exercise their discretionary, contrary to that, in the case of Ato Forson, and say that even in this case of willfully causing financial loss to the state, alleged, which they are here to prove, they are not willing. So that 2 million euros, you claim that somebody has caused financial loss to the state to the tune of 2 million euros. The person says, I'm ready to pay you your money. You say you don't want it. What is the sense in that? Then are you really interested in a loss?
Okay.
Or you're only interested in vendetta?
Thank you. Mr. Chairboy, now, Sami Jemfi says there that in your statement, the earlier statement, you denied categorically that there has never been that particular communication between the AG and the third accused. How do you respond to that?
My brother, that is in the petition. If you have our release there, read it. We said the AG had not met any of the accused persons, or especially the third accused person, to implicate the first accused person, Honorable Cassiel Ato Forson. So the context is different. So it's about meeting him to say, go and do ABC. So we never said that he had never met him on any other matters. So that's the place. You read it well and you realize that one is being taken out.
Brother, can I read what he wrote in the press release?
Oh, okay,
Yeah.
Sami, yes, you can.
Okay, so paragraph 2 of the press release reads, the Republic has never required or desired the cooperation of any of the accused persons in the matter. Never required or desired the cooperation of any of the accused persons in the matter, in which it has already succeeded in establishing a prima facie case against all the accused persons. Neither the Attorney General nor any officer from the Office of the Attorney General has approached any of the accused persons with the view to obtaining evidence from them.
That is what the second point
my brother
says.
Is Lawyer Tia saying
So
that,
Sami, it's okay.
The context
Let Tia respond to this. So lawyer, this is your own statement, word to word, read to you.
What you wrote there is what I just explained. You may meet someone for a different purpose, but the allegation was that he had met the third accused person to ensure that, or in order to ensure that the third accused person implicates the first. And that's the response that we gave. So I don't want us to belabor the point there. In any event,
No. You are not answering the question. My brother,
our
the issue is simple. You said you have never raised out any of the accused persons
because it's so clear.
You have heard the tape.
Sami, allow Tia to make his point. Allow Tia to make his point. You come in. Sami Mv, allow Tia to make his point. You'd come in. So just give him the time for him to make his point.
Yes, if you allow me, my brother, I'm constrained when it comes to commenting on this matter live already because the accused person, in fact, the first accused person has filed an application in court for this matter to be gone into. And so, in fact, I accepted to grant this interview with respect to the request for the broadcast. But the other matters definitely won't get to court. We'll argue that one in court, but not on this particular forum, my brother.
So, Mr. Tia, just this question for me. Looking at where we are now, is it in the consideration of the AG's department to reconsider that plea bargaining request that was put on the table by the third accused?
Yes, plea bargaining is up to the date of final judgment. So if, for example, another request is put in, you cannot say because of this happening, so let's ignore it. Only by law, we are supposed to look at whatever application comes before us. And so plea bargaining is up to the date of judgment.
All right. So that's it. Thank you very much for joining. But let me bring in Professor Kojo Appiagyei-Atua. Prof, grateful for joining. Now, the decision or the request by the minority leader to the CJ is to allow for a live telecast of his trial. What do you say to it?
It's a good idea. I think it will serve the cause of justice and make sure that the issues surrounding the credibility of the office of the Attorney General and the whole bargaining process and the trial itself, I think it has garnered public interest. And so on the same ground that the other case there was a request for a hearing to be made public, it should on that basis be granted as such so that people will get to know what is happening and they will make their informed minds and will be able to help clarify some things that may be agitating people's minds.
Won't it open the floodgate for so many of such requests coming in the future?
Of course, it should be subject to some rules. So one of the key reasons is that it's a case of public interest. And if the case of public interest, the other question is, if you look at the generality of discussions around it and the controversy surrounding it, will it be in the interest of the general public and interest of the general public to ensure that they are properly served by listening and hearing and to learn something from the case directly from the court so that they can also be updated instead of getting bits and pieces of information through radio and television and the media.
Professor Appiagyei-Atua, I'm grateful to you for joining. He is Associate Professor of Other School of Law, University of Ghana. Thank you to you for joining, and also to Sami Jemfi and Alfred Tiayabua. Up next year is Newsnight.